No, but
No, you're in the courtroom. You're all good.
all right.
All right, Miss Azell, how are you, Mr. Kaplan? Ms. Robinson? Ms. Azell, how are we proceeding today?
Your Honor, I believe we are ready on the Hinton case, and it appears the AG would be ready on their case as well.
All right, so I think we have to bring up Hinton, right? Johnny Hinton?
Oh, it should be on Polly. Oops.
Ooh. I don't see Hinton on Polly.
I'll also be ready on Millette.
Let's go on the AG case. On Travis Arnett Brain.
That's not.
Nope, that's not.
Oh, let's see the other one.
Vincent Fochman would be the AG.
Fochman. All right. All right. And then Mr. Trescone, you're here for the AG's office. And Mr. Comorn, you're here for Mr. Fochman or Fochman?
That's correct, Judge.
All right. Is it Fochman or Fochman?
Correct, Fochman.
Fochman, thank you.
Yes, sir.
All right, so we're on the record in docket 25-01122. That is people of the state of Michigan versus Vincent Fochman. Will the parties please introduce themselves to the record? Mr. Trescone.
Mike Trescone for the people.
Mr. Comorn.
Good morning. May it please the court, Michael Comorn for Vincent Fochman, who is present on the Zoom.
And sir, you are Vincent Fochman, is that correct?
Correct.
And you can hear me all right, Mr. Fochman?
Yes, sir.
Thank you. This is the time set for a probable cause conference. Mr. Trescone, how are we proceeding today?
At this point, we're ready for the exam that's set on the 12th. I'd leave that up to Mr. Comorn.
All right, so the Attorney General's position is to leave this on to May 9th at 9:30. Mr. Comorn, what is your response?
I don't think it's May 9th. I think he was referring to June 12th.
That's June 12th.
That's
June
correct.
12th at 8:30.
That's correct. We're prepared to proceed on that day with the exam. I want to make sure that I have all the discovery. I know I've received some stuff. It's all under seal and whatnot, but I will, hopefully I can speak with Attorney General after the proceeding today to ensure that I have what I think exists as far as discovery.
All right, so I will leave this on for preliminary examination for June 12th at 8:30. And then I can place Mr. Trescone and Mr. Comorn, I can place you in a breakout room so you can discuss any discovery issues if you want to proceed that way. But we'll leave on for June 12th. Did you want to be placed in a breakout room to discuss any discovery issues for that June 12th date?
That would work for us, I think.
I think that'd be helpful, Judge.
All right. Let's Mr. Comorn, you had anything else?
I was just going to say, you're going to put us in the breakout room. We're not going to come back. We have our date for the 12th. I just want to confirm that commences at 8:30 a.m.
Correct.
Okay.
All right.
Good.
All right. So we'll put in Mr. Trescone. I'll put you in. You should get a prompt to go to room 1, and then you're all set. Your probable cause conference is done, so you can leave once you're set. Mr. Trescone, you'll get a prompt to go to room 1, and Mr. Comorn, you'll also get a prompt to go to room 1, and then Mr. Fochman, you can take off, and you're all set. All right, sir.
Thank you, sir.
You're welcome. That was Fochman.
All right.
We're getting Hinton.
We would be, I believe we're ready on Mullet.
On Mullet. All right. Paul Mullet.
We're also supposed to be on Polly.
I didn't see him in jail.
I have him in custody.
I just checked the Enum County inmate locator. He's not there. He's going to
Did he get out yesterday, maybe?
I don't know.
Let's find out where Mr. Mullet is.
No, I called Brian Millette.
Yeah,
He's in jail?
Custody, yep. He was booked the 21st.
so he should be
I
on
just
Zoom.
don't know why.
I don't know why they're not putting him on Polly. I'm on.
Mullet,
There's 3 of them that need to be on Polly.
Hinton, and O'Reilly should be on Paul.
they're not putting them on BindLink is the problem, so I'm not scheduling, Polycom meetings beforehand.
So
because-
if you need to meet with Mr. Millet, we can arrange that.
I do, thank you.
I can let you know whenever they put them on Poly.
Yeah.
'Cause
All right.
they're scheduled for 8:30 and it's now 9 and they're still not on.
Oh, so they're not even logged on.
No, this is-
All right.
Because I have Hinton, Millette, and O'Reilly all in custody.
do you have your witnesses here for Brain Arnett or
I
Arnett?
got a couple in Buchanan. so
I'm sorry?
down.
Because I have that pro per. Arnett, the first one, Arnett Brain,
Right, I have it set for a probable cause conference.
right? Oh, so you won't have any witnesses? here.
Yeah, sorry.
Is he here?
He is here, and then I have been talking to Mr. Kuntz about this case because he is going to be retaining Mr. Kuntz. They're in
Okay,
the
because
process
he
of that.
denied it, okay. So is Mr. Kuntz gonna represent him?
I think so.
All right.
I'm gonna see if I can't find him.
So I'll put that on the record. He might have to, because, all right, so there's Mr. Kuntz. So Mr. Kuntz, are you here on Arnett Brain?
Yes, Your Honor, I would say limited appearance.
Limited
for the
appearance?
purposes Of this PCC right now.
All right,
The idea is
Did-
I'll be coming
did-
long term.
did you want to talk with Mrs. L?
We've spoken.
Okay. All right, let's go ahead and call that case then. All right, so we are on the record in docket 25-01476. That is People of the State of Michigan versus Travis Arnett Brain. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
And Mr. Kuntz, you're filing a limited appearance until you file an actual appearance. Is that correct?
That's right, Your Honor.
Okay, you can go ahead and say your name for the records.
Good morning, Your Honor. Dustin Coons for Travis Arnett Brain. Okay.
And sir, you are Travis Arnett Brain, is that correct?
Yes, sir.
And you can hear me all right, Mr. Brain?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Mrs. L, how are we proceeding? I know Mr. Kuntz just got involved in the case. So I'll allow everybody to make a record.
Thank you, Your Honor. It is my understanding that at this time, we'd be asking for an adjournment to allow Mr. Kuntz the opportunity to get discovery, review that discovery, and go through it with his client.
So you'd be requesting a second PCC.
We would be, Your Honor.
And is that a fair statement, Mr. Kuntz?
It is, Your Honor. I would also add just one other thing before we get a date. I'm scheduled to begin a capital trial in front of Judge Aquilina 2 weeks from today.
Right.
I think it's going to go at least a week.
Maybe, maybe longer.
Yeah, probably. Yeah, I can see it going up to 2.
Yeah.
So,
So first of all, and I don't know if you've had the opportunity to discuss this with Mr. Arnett Brain. He's entitled to a prelim within 21 days, as you know. So if he's willing to waive the 21 days, then we can bounce it further after you're confident that your schedule would fit.
yes, and we've discussed that.
All right, perfect. May I inquire of Mr. Arnett Brain of his waiver of the 21 days?
Yes, please, Your Honor.
All right, thank you. Mr. Arnett Brain, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dustin Kuntz. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a prelim only within the 21 days. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. So we can set it past Mr. Kuntz's trial schedule and set it for a date where we would be setting it for another probable cause conference. Mr. Kuntz would get all the discovery on your behalf, and then he could zealously advocate your defense. Is it your wish today to waive your right to a prelim within 21 days?
Yes, sir.
Mrs. L, do you also waive the people's right to a prelim within 21 days?
We do, Your Honor.
All right, now let's get the date, okay? So when does that date, when does the trial start, Mr. Kuntz?
June 13th.
All right, so June 13th, do you think June would be you think the 26th or 27th would work? That's only a week, that's like a week and a half.
Yeah, I think so. And if it's running long, I can keep everyone.
All right, just let us know. And then, so let's look at the last week of June.
June 27th at 8:30.
All right. So we'll adjourn. I'm going to indicate the defendant has waived his 21-day rule. We will expect a full appearance from Mr. Coons on the file, and then that's when discovery will take place. And then we'll set for June 27th. So we'll set for PCC. So that was
It's a PCC.
It's PCC day. Okay, June 27th at 8:30, and then let's hold off on the prelim until we see the schedule, and we'll set the prelim after that. Okay.
Right.
Now that we waived the 21-day rule. All right. Anything else for the record in docket 25-01-476, Mrs. Zell?
Not for the people?
Mr. Coons?
No, thank you, Your Honor.
All right, Mr. Arnett, Brain, we'll see you on that June 27th date. Thank you.
I'll have a notice for you in a second, if you want to. I'll have a notice for you in a second.
I do that, put it in the file. That's what I did.
Oh.
What I do with the documents.
We're also ready on Julian Mills.
Julian Mills.
I gotta get a reprint it.
It's taking its.
And is that a
Yeah, I
proper
know.
also,
I just
or is that?
That is Mr. Coons as well.
Okay, perfect. All right, so we're on the record in docket 25. Are you ready to go? I didn't even think, and we do have somebody on Polycom.
Yes, I emailed them.
All right, so we're on the record in docket 25-01-453. That's people of the state of Michigan versus Julian Mills. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Coons.
Morning, Your Honor. Dustin Coons for Julian Mills, who's here to my right.
And sir, you are Julian Mills, is that correct? Thank you. This is time set for PCC conference. Mrs. Zell, how are we proceeding? And then I'll give the opportunity to everybody to make a record.
Your Honor, it's my understanding that there will be a request for an adjournment in this case as well. I will have to defer to Mr. Coons on that.
All right, Mr. Coons.
That's right, Your Honor. The purpose for this request for 21-day waiver and adjournment is there is an offer from the people on this case. It may be one that my client ends up accepting, but I want to have a little time to put together a deviation letter that Mrs. Zell can review to see if we can work out something else. So further negotiations.
Further negotiations, and have you received any discovery in this matter yet?
Yes, Your Honor.
Okay, so this is still in negotiation.
Yes.
All right, may I inquire of your client, Mr. Mills, of the waiver of the 21-day rule?
You may, Your Honor. And if I could just supplement one more thing on the record.
Sure.
I'm confident this is going to end up being a district court resolution.
Okay.
One way or the other, so.
All right. All right, Mr. Mills, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dustin Coons, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a prelim within the 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so negotiations can continue between Mr. Coons and the people of the state of Michigan. Is it your wish today to waive your right to a prelim within 21 days?
Yes, sir.
Mrs. Zell, do you also waive the people's right to a prelim within 21 days?
We do, Your Honor.
All right. I find that the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And are we looking to reset this for PCC or prelim? It doesn't matter.
I think another PCC would be fine.
All right, and that would be outside of the trial schedule, like the last one.
Yes, Your
Yeah.
Honor.
I would
We
think.
do it before the trial schedule.
I don't know.
Like
There's
the 12th.
we could do the 12th, or we could do the same date, because we've already set that same date. So that would all depend on your schedule, Mr. Coons. If you want it looked at before, or if you want it looked at the same date of, that's in June 27th. Yep.
My preference would be the 27th, Your Honor, but if
since we know you're gonna be here on the other case, let's set it for June 27th at 8:30. 8:30 for PCC. All right, we'll set it for June 27th at 8:30 for PCC. That should give the parties enough time, plenty of time to negotiate. And then we'll see you on that date, all right, sir?
Yes.
Anything else for the record in docket 25-01453, Mrs. L?
Nothing, people.
Mr. Coons?
No, thank you, Your Honor.
You're all set. Thank you for your appearance today.
I'll have a notice for you in a second. You want one?
Ma'am, in the Ingham County Jail, or sir, in the Ingham County Jail Post, would you identify yourself, please?
Johnny Hinton.
Johnny Hinton, all right, thank you. You're in the right place, Mr. Hinton. We're gonna get your attorney and then we'll be, but you should stand by, all right, sir?
Yes, sir.
Thank you.
Isn't that you?
I can get loud.
No. All right, Mr. Hinton, your attorney was right here all this time, so. All right, so we're on the record in docket 25-01360. That's people of the state of Michigan versus Johnny Hinton. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Hinton.
And sir, you are Johnny Hinton, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Hinton?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Mrs. L, how we proceed?
Your Honor, it's my understanding we are going to be leaving the set for a preliminary examination.
And is that a fair statement, Ms. Robinson?
It is.
So we'll leave on for preliminary examination for June 6th at 8:30. So this is left on for, can't read my own, for next Friday at 8:30. Anything else for the record in docket 25-01360, Mrs. L?
Not for the people.
Ms. Robinson.
No, Your Honor, thank you.
All right, Mr. Hinton, we'll see you next week at 8:30. Thank you for your appearance today.
Thank you, Your Honor.
Hi. I can't hear. Can't hear. No sound.
All right, Miss O'Reilly, I'm gonna place you in a breakout room with your lawyer, Miss Robinson. And then when she joins, I'm gonna place you in room 2. So you'll go to room 2, and then when Miss Robinson joins us, she'll also go to room 2.
Thank you.
You're welcome.
I've got to do a video
As opposed
hearing
to
over the weekend as well. They're not logged on there either. I'm gonna pop over there, so if
all right, so we're on the record in docket 25-01484. That is People of the State of Michigan versus Courtney L. O'Reilly. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Miss Robinson.
Erin Robinson, Assistant Public Defender for Ms. O'Reilly.
And ma'am, you are Courtney O'Reilly, is that correct?
I am.
All right, thank you. And you can hear me all right, Miss O'Reilly?
I can.
Thank you. This is the time set for PCC in the matter. Miss Zell, how are we proceeding today?
Your Honor, at this time, the people have extended a plea offer to defendant through defense counsel. That offer would be to plead to an added count 2 of larceny 200 to 1,000 under MCL 750.3564A, which is a 1-year misdemeanor and/or $2,000 fine. Upon successful plea and sentence, we would be dismissing count 1, the larceny in a building.
So it's a plea to larceny 200 to 1,000 under 750.3564A. That's 1 year and/or $2,000. With a successful plea and sentence, count 1 is to be dismissed, which is the larceny building. Is that correct?
That is correct, Your Honor.
Is that your understanding, Ms. Robinson, of the plea agreement?
It is.
All right. May I inquire of Ms. O'Reilly of her advice of misdemeanor rights?
You may.
All right. Ms. O'Reilly, you understand you'd be pleading guilty to a 1-year misdemeanor and/or $2,000 with the understanding that count one, the larceny of building, the 4-year felony is dismissed. And you have some jury trial rights in this misdemeanor file, and I'll walk you through those rights. All right, ma'am?
All right.
All right. You understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
I understand.
All right. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was results of any promises other than what's been stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to have a trial, to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor count instead. Is it still your wish to waive your jury trial rights and plead guilty to the misdemeanor count of larceny, $200 to $1,000?
Yes, Your Honor.
Okay, I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I solemnly swear to tell the truth and the whole truth.
Okay. I'm going to bring your attention back to May 15th, 2025 at the offense location of 228 Museum Drive in the city of Lansing. Were you at the location in the city of Lansing at 228 Museum Drive on May 15th, 2025?
I was.
All right. And at that time, did you?
Sorry, Your Honor. Assuming that's what the
Okay.
time was,
All right. So May 15th and in the city of Lansing is correct.
Yes.
Okay. And at that time and place, did you take a backpack, keys, wallet, and phone from somebody else's backpack?
Yes.
Okay. And you knew when you took it, it wasn't done by accident. You did it knowing that it was that you were taking the backpack, keys, and wallet from somebody else's backpack, that you didn't have any authority to take that.
Yes, Your Honor.
All right. Anything towards a factual basis, Mrs. L?
No, Your Honor.
Miss Robinson?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, accurately made in regards to both count one and count two, depending. I mean, I don't think we didn't make it clear that it was a theater that she took it from for the larceny building. I think this fits the 200 to 1,000. So we will refer to probation. So Miss O'Reilly, probation may be down to see you, depending, or if you're out, you should contact probation. You're in right now, so probation would be down to see you. And then we'll set a date for sentencing. And a sentencing date would be
July 25th.
July 25th at 8:30. So probation will be down to see you unless you're out, and then you should report to probation within 48 hours. All right, ma'am?
All right. Thank you, Your Honor.
All right.
What time was it? I'm sorry.
July 25th at 8:30.
8:30. Thank you.
Anything towards anything else concerning 25-01484, Mrs. L?
Not going to be both.
Ms. Robinson?
I'd like to address bond, Judge.
All right, you may address bond.
Yes, Your Honor, we'd ask the court to convert Ms. O'Reilly's bond to a personal recognizance bond, as she did plead to a misdemeanor account. She does have family on the outside in which they can help her and make sure that she gets her report dates and everything on time. I believe this is going to likely be a probation type of offense, so we would ask for a personal recognizance bond.
Do we have, there seemed to be at arraignment, there was no address given. Does she have an address?
Ms. O'Reilly, do you have an address for your parents?
I have my parents' address. Would you like it?
Yeah, could you update with your, just update for the court file, the parents' address? They'll receive notification, or that the notification will be sent to that address for any new hearings.
Okay. Do I give it
So
right
what's-
now or?
Yeah, what, do you have that right now?
Yeah, it's 2617 Lafayette, Lafayette Avenue, Lansing, Michigan.
Do you have a zip code there?
48906.
Okay, 4906. Mrs. Zell, response to the motion to PR bond this.
We would leave this to the court's discretion. We have no indication that Ms. O'Reilly would not appear for her court dates. And with the lowering of the charge, we wouldn't have any objection here.
This is a misdemeanor charge of $200 to $1,000. We do have a current address. Although at arraignment, there was, Ms. O'Reilly was homeless, but we have a current address. Do you plan to be staying at that address, Ms. O'Reilly?
If my parents allow me to, but at the very least, I will be able to receive mail from that
Okay.
address. But I plan to stay there if my parents allow it.
All right. I do think that there should be a modification of bond since this was a felony. But I'm not going to lower it to a PR bond, okay? So we'll set it at $1,000, 10%. So it'll be $100 bond, which is a reduction from the $5,000, 10%. So I've reduced to $1,000, 10%. Anything else for the record in 2501484, Mrs. Zell?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, Ms. O'Reilly, it's set at $100. We've got the new address. Thank you for your appearance today. You're all set.
Thank you, Your Honor. Hello?
All right, Mr. Millet, we're waiting for Mr. Kaplan to join us, and we'll put it on the record. Okay?
Honor? Your Honor?
Yeah, we're gonna put it on the record, sir.
I had that other case in front of you too. I'd like to see if we can address that now too, so I don't have to come back on Zoom or whatever, because I don't know where my phone is.
Mr. Millet, we'll address that after.
Yeah, I don't have the file in front of me, so we're just gonna do this case for now. All right, so we're on the record in docket. But did you need to speak with Mrs. L?
Nah, I've talked to her enough.
All right, so we're on the record in docket 25-01515. That is People of the State of Michigan versus Paul Millet. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Kaplan.
Your Honor, Jeffrey Kaplan, P74943, on behalf of the defendant who's appearing by Zoom.
And sir, you are Paul Millet, is that correct?
Yes, sir.
And you can hear me all right, Mr. Millet? All right, this is the time set for a probable cause conference. Ms. Zell, how are we proceeding today, or would you like to defer?
Your Honor, at this time, a plea offer has been extended to the defendant through defense counsel. That offer is to plead to a added count 2 of controlled substance use under 333.74042B.
You have to say that again.
Sorry. Okay.
That's no, I just wasn't.
No, you're okay.
I got lost.
333.74042B.
All right.
That's the 1 year misdemeanor and or $1,000 fine.
All right.
Upon successful plea and sentence, we would be dismissing count 1 and the habitual offender.
Okay, so plea, so that'd be a dismissal of count 1 and habitual.
Correct.
Is that a fair statement, Mr. Kaplan?
It is. The habitual wouldn't apply because it's a misdemeanor anyway. So.
And does Mr. Millet plan to take the offer that's been extended by the prosecutor's office?
As he explained to me, Your Honor, he would take that as quickly as possible.
Okay. All right, may I inquire of your client of his misdemeanor advice of rights?
You can, Your Honor.
All right. Mr. Millet, you understand you have the right in this misdemeanor file, and you have the following jury trial rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Mr. Kaplan, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand? Mr. Kaplan's role in this, sir?
Absolutely, sir.
You have the right to have the court-ordered witnesses appear in your defense, to remain silent during the trial, not to have the silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's stated on the record, or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the 1 year misdemeanor use of methamphetamine. Is it still your wish today to waive your jury trial rights and plead guilty to the 1 year use of methamphetamine misdemeanor?
Absolutely, sir.
All right, I'm gonna have you raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, I'm gonna bring your attention back to 120 West Michigan Avenue in the city of Lansing on May 20th, 2025. Were you in the city of Lansing on May 20th, 2025 on that date and time?
Yes, sir.
And at that time, did you knowingly use methamphetamine?
Yes, sir.
And you knew it was methamphetamine at the time?
Yes, sir.
And you didn't have a prescription for it?
Yes, sir.
All
I
right.
didn't have one.
Anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Kaplan?
Just to ask, you didn't have any other lawful reason to possess that methamphetamine, did you?
No, I was just using it, but
Okay.
on my behalf there, I got on
We don't-
subtext when I
we
was
don't
in
need-
here.
Mr.
and,
Millette?
Other stuff.
You
Yeah,
don't need any other explanation, just the yes or no, that's all.
All right.
Why are you saying anything else that's gonna get you in trouble?
Anything towards the factual basis of Mr. Kaplan?
No, nothing else.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. So probation, will refer to probation. Probation will be down to see Mr. Millette if he's incarcerated. If he's out, Mr. Millette should contact probation within 48 hours of his release. But if he's incarcerated, probation will be down to see him. And we'll set a sentencing date of July 25th at 9 o'clock. Anything else for the record in 25-01515, Mrs. L?
Not for people.
Mr. Kaplan?
Brenner, would you entertain a bond motion?
I wouldn't.
Thank you, Your Honor. This has now been reduced to a misdemeanor, nonviolent misdemeanor. My client is employed. Our intake, she says he does building maintenance. But he also tells me that he does work as a bondsman. I don't know how that would be affected by this. In any event, Your Honor, we would ask for Your Honor to consider a PR bond now that this has been reduced to a nonviolent misdemeanor.
All right, thank you, Mr. Kaplan. Mrs. L, response.
Your Honor, we would leave it up to the court's discretion at this time.
I did the arraignment and set the arraignment at $1,000, 10% on the felony. He's now pled to a misdemeanor. So I will modify bond. There was no pretrial report done because they indicated because they didn't want to wake him. I don't know if that's an actual reason or not, but that's the reason they gave. I do have some prior criminal history in regards to an OWI and a couple of RNOs. Nothing concerning, I don't see anything concerning possession. I'll modify bond to read. So it's $1,000, 10%. We'll go 1,500 PR bond.
Thank you, Your Honor.
Which is a reduction from the 1,010%, which is a 4-year felony set at arraignment. Now he's pled to use of controlled substance, and that would bring it down to modify the bond to the PR bond. So
sure,
you're going to be out, Mr.
Another
Millette.
case for like $10, I think.
Oh, you've got the other case.
He's got a civil infraction, Your Honor, that I don't represent him on.
Right. All right.
But I got a
If you're out,
$10 bond.
all right. If you're out, Mr. Millette, you need to contact probation. If you're still in, the probation will be there to contact you. All right.
Am I gonna still have a $10 bond?
You've got a PR bond on this file, so you don't have a $10 bond on this file anymore. It was a 1,010%, so it was $100 on this file. Now it's a PR bond, so you're out on this file. I don't know if you've got anything else.
Yes.
So you got a $10 posting on a misdemeanor.
His misdemeanor is at 110%.
So you've still got a $10 bond. Yeah.
It's in the other case.
That's on the other file. That's on the other file. This file you're PR'd.
Thank you.
So if you're out, contact probation. If you're not, probation will be down to see you. All right, sir?
Okay, thank you.
All right, you're all set.
Thank you, Your Honor.
Thank you, Mr. Kaplan.